Judgment in the matter of Glasgow City Council against X.
Lady Simler will provide a summary of the judgment in this case.
This case is about the scope of the duty imposed on local authorities in Scotland to secure temporary accommodation for homeless people in specified circumstances. The appellant and her family were granted asylum and refugee status in 2020. Her family consists of the appellant, her husband, and 4 children. One of the children is a son with autism and special needs. The effect of the grant of refugee status was that the family were no longer entitled to Home Office accommodation, and they became homeless. In turn, that meant that the obligation to house them passed to Glasgow City Council. Glasgow City Council is the respondent local authority in this case. In 2021, the respondent local authority secured temporary accommodation for the family in accordance with the mandatory duty to secure interim accommodation under Section 29, subsection 1 of the Housing Scotland Act 1987. The accommodation was a 4-apartment property. That means it had 3 bedrooms and a living room. The respondent local authority investigated the housing needs of the appellant and her family. It assessed the family as needing a 5-apartment property, 4 bedrooms and a living room, in order to accommodate their son's additional support needs. The difficulty, however, that was faced by the respondent was that 5-apartment properties were in short supply. That meant that larger households had to wait longer for an offer of settled housing. The appellant brought judicial review proceedings to challenge the 4-apartment accommodation provided to her as unsuitable because it didn't meet all the needs of her family. She argued that the respondent acted unlawfully in securing it on her behalf, relying on Article 4B of the Homeless Persons Unsuitable Accommodation Scotland Order 2014. That order sets out what is unsuitable accommodation in all circumstances where the interim duty to secure temporary accommodation arises. The question on this appeal is whether temporary accommodation is unsuitable within the meaning of the 2014 order, unless it meets all the needs of a homeless applicant and each member of the applicant's household, in other words, all those living with her. The answer to that question depends on the meaning and effect of the phrase in Article 4B of the 2014 order, which requires the local authority to, quotes, take into account the needs of the household. The Outer House of the Court of Session decided that the respondent local authority had acted unlawfully by providing the appellant with unsuitable temporary accommodation because it didn't meet the needs of the household. That decision was overturned by the Inner House in favour of the respondent. The Supreme Court unanimously dismisses this appeal. I give the judgment with which the other justices agree. In the judgment, I explain that in order to resolve the question of what is required of a local authority in this situation, the starting point must be to consider the duties imposed by the 1987 Act and the 2014 order in respect of people facing the immediate problem of homelessness. The 1987 Act imposes 2 separate duties. First, an interim duty to secure temporary accommodation imposed by Section 29, and then a duty to secure permanent accommodation imposed by Section 31. There is a fundamental distinction drawn by the words of the 1987 Act and the 2014 order between the Section 31 duty, which is to meet needs in relation to permanent accommodation, and the Section 29 duty, which is to take account of needs in relation to temporary accommodation. The first duty for permanent accommodation is a results-driven duty. The second duty for temporary accommodation is a process duty requiring needs to be considered, but not requiring them to be met. That distinction is unsurprising. The scheme envisages that a local authority will come under a duty to secure temporary accommodation before a full needs assessment can take place. It's therefore understandable that no obligation to achieve a particular outcome is imposed at the interim duty stage. On the other hand, the strikingly different language in the provisions dealing with permanent accommodation reflect the fact that the obligation to secure permanent accommodation is more demanding. That difference is also important. Accommodation provided temporarily is a staging post along the way to permanent accommodation. As a matter of practical reality, there are likely to be cases where what is suitable for a homeless person to occupy on a temporary basis while the authority completes its inquiries or looks for permanent accommodation will be different to what is suitable in the longer term. Where the legislature intends the 2014 order to provide that accommodation will be unsuitable unless it meets a certain requirement or need, it says so plainly and clearly. The 2014 order also specifies other additional suitability factors which can be derogated from in an emergency, but Article 4, the duty to take account of the needs of the household in providing suitable accommodation, cannot be disapplied. If the appellant were right, that Article 4 means that a local authority has to meet all the needs of an applicant and her household, that would mean that the local authority could derogate from various other requirements in an emergency, but would remain under a duty to meet all the needs of the household. That would produce an incoherent scheme. So applying the scheme properly understood to the facts of this case, the accommodation secured for the appellant by the respondent did not meet the needs of her household, as permanent accommodation would have to have done, but it was not required to do so. The respondent was simply required to take account of those needs in deciding what accommodation would be suitable, and the evidence showed that that is precisely what the respondent had done. The respondent's decision had therefore had proper regard for the requirements of the 2014 order, having taken into account the household's needs, and it was accordingly a lawful decision. For those reasons, the appeal is unanimously dismissed.